County Board of Commissioners of Jackson County study session to order. Madam Clerk, could you call the roll?
Yes, Mr. Chair. Commissioner Leitner? Here. Commissioner Walls? Here. Commissioner Rice?
Here.
Commissioner Duckham? Commissioner Duckham? Here. Commissioner Alexander? Present. Commissioner Mahoney? Here. Commissioner Placzek?
Here.
Commissioner Elwell?
Here.
Chairman Shotwell?
Here.
All present.
At this time, we've arrived at the first opportunity for public comment. Please remember that you have 5 minutes and 5 minutes only. The Board of Commissioners will not answer questions. You may direct them towards the administrator, and if he so chooses later in the meeting, he may readdress those issues. I didn't think you'd disappoint.
I appreciate that, Chairman. Ladies and gentlemen, my name is Kevin Thompson. I'm an attorney. I'm the attorney for Hanover and Liberty Township. I want to address you on the SRI bond debt issue, which is obviously a very major issue before the study commission, the study session this morning, given the notice of default that's been tendered by Leone Township. It's going to come down to the county commission decision on how to apportion the debt, the allocation of the payment of the debt, I should say, with respect to the sum that's ultimately going to be paid by the county on the bond payment that comes up in fairly short order, July 1st. It's amazing how fast time goes by. The issue that really falls before the court is, listen to me, I apologize. But before the commission is the issue on how to apportion the debt. We have a roadmap that's been established, and I'm sure you'll hear from others. And that roadmap that was established was Judge LaFlamme's opinion, written some time ago with respect to the various parties' responsibility for the debt payment. The most important thing is that Judge LaFlamme ruled, and we're bound by his ruling, and that's that contract is not ambiguous. And I know that the Board of Public Works yesterday supported a proposition that would indicate that a ad valorem tax be levied upon the Township of Leone to pay for that. And that is provided in the contract, and that's on page 8 of the contract. I certainly wouldn't profess to indicate that any of you should read that contract and be intimately familiar with it. I've been involved in it. Mr. Daniels has been involved in it. We've all been involved in it for a long time, and it's a complicated document. That is, under the contract, it is proper for the county to levy an ad valorem tax on Leone Township. The problem, and that's not contrary to the court's opinion, by the way. The court's opinion actually indicated that the ultimate fee would be upon the users. Well, we only have about 800 users, and as Mr. Overton, I think, correctly indicated yesterday, it'd be about a $700 to $800 a year fee on the 700 or 800 users on the Hanover and Liberty line, which is just draconian with respect to the remaining debt that's outstanding. The board could levy an ad valorem tax on Liberty and Hanover and Columbia Township too. You're going to get a kickback from Columbia Township on that because there are only 5 commercial customers that are actually on the Southern Interceptor line. And that's the businesses centered at 127 and Jefferson, and including Liberty Landfill. And so we're faced with a very difficult issue, but I would indicate to the board that from my standpoint, the most equitable way to handle this is to spread the debt out on as many individuals as possible. I understand the Board of Public Works yesterday indicated an ad valorem on Leone only is the appropriate way to do that. But what I had indicated to the Board of Public Works yesterday, and I want this board to realize, is that the Plant Moran audit, which we all hoped would provide a little more light on the issue, didn't. I've not seen the updated, I would like a copy of that, but the fact is that there's about $3 million in unrestricted funds that I'd like this board to carefully consider the fact that if there's unrestricted funds in that account, and ultimately when the bonds are paid off, that system's going to be owned by Leone Township. Leone Township certainly has the funds available today to make the next bond payment. And so I'd ask this board to carefully consider not only the recommendation that was provided to this board by the Board of Public Works, but also to consider the financial aspect of the unrestricted funds that are sitting in the account at Leone, at the wastewater treatment plant, and that ultimately, should this board decide how to apportion the tax, the most equitable solution, and I'm stepping on a few toes on the constituencies that I represent as well, but I believe the most equitable
Kevin?
way is to spread that over.
You're over time.
Thank you very much. I apologize for going over time. Thank you for your attention. I'm usually told just to shut up. Thank you very much.
Good morning, members of the board and Mr. Overton. My name is Tom Daniels. I'm the attorney who represented Leone Township in the litigation that Kevin Thompson just directed your attention to. And I agree with Mr. Thompson that Judge Laflamme did give to this board and to the county and to all the parties that are involved in this matter a roadmap. The roadmap was very simple and straightforward. The townships, Columbia, Hanover, and Liberty, argued to Judge Laflamme in the litigation that everyone within the Regional Utility Authority, all the townships, all 13 members of the authority should pay the SRI bond debt. The judge rejected that argument, and in fact, what he found was as follows. As Mr. Thompson pointed out, the contract is not ambiguous, it's very clear. The provisions of the bond contract, I'm quoting the judge now, which speak to Leone's obligations to make bond payments, speak only to Leone's obligation as primary pledgeor of its full faith and credit to the county to assure that all bond payments are made. None of the provisions that obligate Leone to make these payments speaks to the ultimate source of the funds to be used. Page 6. The bond contract, again, these are quotes directly from Judge Laflamme, read as a whole, does indeed provide for all revenue for the payment of the bonds come ultimately from the townships. There he's referring to Columbia, Hanover, and Liberty. Page 2. Again, the intended ultimate source of the funds used or to be used to be paid the bond debt is the users of the system in each township, again referring to Columbia, Hanover, and Liberty Township. That was a rejection of the position taken by the townships. That was the practical, sensible, correct ruling under the contract itself and under the concept of the fact that the parties that actually use the system, like everybody else within the LRUA, pay their own debt service on their own individual systems, that the parties that use the system are the parties that would pay for the system. Now, relative to the Plant Moran report that Mr. Thompson also referred to, the report could have been a little bit more thorough, but on the ultimate question that you wanted Plant Moran to address and answer for you, this is what Plant Moran said. At the time of the agreement, there was significant growth projected for this region of the county, and the fees charged to connect to the SRI were intended to cover the debt service payments made by Leone Township. The projected growth did not materialize, and Leone has been forced to use other sewer system resources to pay the debt service. A quote, although the intent of the SRI was to collect connection fees in order to make the annual debt service payments, the amounts collected related to just the SRI system, connection fees, and debt service have been significantly less than the debt service payments. In their conclusion, while the township has segmented the connection fee and additional contributions for debt service, these amounts have been insufficient to cover the debt service payments to date. The reason for that is that the townships, that the judge said, clearly had the responsibility to pay the debt service have not paid the debt service. And the connection fees that were expected have simply not been sufficient by any means. The exact numbers of the connection fees that have been paid are laid out in the Plant Moran report. This is the most recent one. The one that I'm referring to now is dated May 8th, 2015. So again, if people are going to appear before the board and talk to you about what the judge did and what sort of a roadmap the judge gave to you, that's the roadmap that the judge gave to you. The judge couldn't have been more clear in his opinion that the responsibility under the SRI bond contract for the debt service payments on the SRI, the system used by Columbia, Hanover, and Liberty, is Columbia, Hanover, and Liberty. Thank you very much.
Good morning, everybody. Brian Hilderley. I'm an attorney and I'm representing Columbia Township. I just want to clarify a few things Mr. Thompson and Mr. Daniels said. Most of what they said is accurate. However, there's a couple of distinctions and a couple of things that were left out. First and foremost, this business about connection fees is irrelevant. It does not matter whether connection fees met projections or not. The judge said it in his opinion. There's nothing in the bond contract that talks about connection fees being the sole source of revenue to pay off these bond debts. There is nothing in the bond contract that talks about what happens if connection fees fall short of projections. So whether or not we had enough connection fees to pay the bond debt is irrelevant to this conversation. So we shouldn't even be talking about it. Second, while this is going to sound like legal nitpicking, when you read the judge's opinion, you can interpret it the way that Mr. Daniels is interpreting it, but what he's missing is the judge said that the townships, the users of the system, are the source of the funds to pay off the bond debt. He did not say that the townships are to pay off the bond debt. The townships, the users of the system, do provide funds. We provide rates. We pay the rates that we're told to pay. If we're told to raise rates, we raise rates. So the townships do provide those funds in order for Leone to meet its obligation to pay the bond debt. So while he says we're the source of the funds, he does not say that we are responsible for paying the bond debt. We being Hanover, Columbia, and Liberty. Sorry. It's when you look at and see how many users are on this particular system, you'll see that it could never have been the intent that these 570 REUs were going to pay for this entire system. The bond contract is clear that Leone is pledging all of its revenue from its entire from the entire system to back its full faith and credit. Hanover, Columbia, and Liberty provide the funds necessary to meet the bond debt. The Plant Moran rate study concludes that they have sufficient funds and they do charge rates sufficient to meet those expenses. There is no separate, the Plant Moran audit or rate study talked about there not being any separation within Leone's accounting system with regards to the SRI. So the funds are available. The other item with regards to Judge LaFlamme's opinion is the county only gets involved in the event there's a need for additional funds. You can go through the bond contract and you can look through Judge LaFlamme's opinion. It's if Leone puts notice that there's a need for additional funds, the county then does something to make that determination whether or not there is a need for additional funds. If it determines that there is, then the county can take some action. But if there's no determination that there's a need for additional funds, then there is no need for county action. So when you read the rate study done by Plant Moran, it says there's plenty of money to make these bond payments. So the county really doesn't have, unless they're going to read something else into that rate study, I don't believe the county has any room to act on that, because you did do something. You engaged Plant Moran to do this rate study, and they concluded that there's sufficient funds. So there's no need for the county to do anything other than to direct Leone to turn over the funds that they've been collecting all along from users of the system. Thank you.
Todd Britton, Leone Township. I'll try to make it in 5 minutes. Sylvan Linden are townships in Washtenaw County. They have a special assessment district set up to pay for their lines. They're not in Jackson County, but they're tied into the sewer system. The village of Grass Lake, they had a separate system put together, a special assessment to pay for their lines. Rod can attest to that. The township of Grass Lake, they had a special assessment district set up to pay for the lines in their township. Blackman Township, they had a special assessment to pay for the lines in Blackman Township. Leone Township, we had a special assessment district for all our lines set up to pay for our lines. The Common Fund, which is Grass Lake Township and Napoleon Township, there was a special assessment district set up to pay for their lines. Columbia Township, which is here today, they had a special assessment district set up to pay for the line that the SRI goes through Columbia Township's Clark Lake line to get to Leone Township. That was a special assessment district. The SRI, which is what we're here to argue about or talk about, there is no special assessment district set up. Back in 2004, I think it was December 14th, we had a county commission meeting. I was present at that meeting. Janet Rochford came before all the commissioners. She said, look, you're going to need to have a special assessment district set up for this to pay for this line. If you don't, something down the line could happen, which Jeff Snyder got up there and said, oh, there's no need. Somerset and Lake Leanne, they're going to tie in. You're going to have more than enough customers, more than enough connection fees, more than enough to make all the payments on this. It never happened. It still today has not happened. If that would have happened, we wouldn't be in this boat. Or if we would have set up a special assessment district for the SRI, we wouldn't be here today either. There were signed contracts by Columbia, Hanover, and Liberty that specifically, it states in there the townships, and that's what our attorney is referred to and Judge LaFlame is referred to, and it specifically says in the contract the townships, Columbia, Hanover, and Liberty, they are responsible to make this payment. If you are going to try and say Leone Township owes all this, you can charge all of our residents, but we're going to have to turn around and charge Sylvan, Linden, Napoleon, Grass Lake. We're going to have to charge every customer on the city or on that system to pay that bill for Leone Township. You can put an ad valorem tax on Leone Township, but we're going to have to turn around and charge it to everybody else. Because our residents that aren't even hooked up to the line, why should we have to pay for a line that there was no special assessment district set up? And I mean, there's a bunch of baloney being spoke today, because the money that's in the fund that they're saying we can make this SRI bond payment for is money that is set aside for the treatment plant. They didn't mention that. That money is set aside just strictly for the treatment plant. It's not set aside to pay for that SRI bond debt. That'd be like me saving my money all month to pay for groceries and then go pay for the bond or pay for the car payment on my neighbor's car. I mean, they don't want to mention that type of thing. That money is specifically set up for a special purpose. I mean, if you look back and just look at the judge's ruling, that's all you need to go by. The vote yesterday, I can understand where that would come in, because, Steve Shotwell, he represents Liberty Township. Those residents in there are tied in. They're going to affect his constituents. Same with Julie. Her constituents are Hanover, Columbia. If I was in their shoes, I would have voted the way that I did too. So I don't blame you for that. I just don't think it's right. So, thank you.
Dan Weimer, Napoleon Township. I've followed this unfolding debate for many years. I sat through all the court sessions before Judge Laflamme, listened to all the arguments on this matter, and I've studied the opinion closely. I guess the one thought that I would offer is, if you make this as a political decision rather than based on the law and the judge's decision, studying it closely, we will all end up back in court. As Todd spoke about, and as you're facing right now, you're facing a budget shortfall. And if you were to take any individual item in your budget and look at how much money you have, you would conclude, I have enough money for that. The problem comes when you look at everything together, as Todd referred to. Some money is destined for other purposes, and you can't just pull from the pot and make a Southern Interceptor bond payment or any other individual item in isolation of your other obligations. So, again, I would urge you to look at the law, look at Judge Laflamme's opinion. The one thing about the courts is we can all argue about what contracts mean or what the law means. Judges can actually clarify reality and change reality with their decisions. And the ambiguity of the Southern Interceptor bond contract, much of it is removed by the judge's decision, his conclusion that the contract is clear on what its intent was. So please look closely at that before you vote. That's more important than any recommendation that anybody else will make to you. Thank you.
This is South Central Michigan Works, and we have some guests to explain the reorganization. Adam, do you want to add anything before he gets started?
Just to introduce our guest, we have Sarah Hartzler and Marcus, and I didn't get Marcus's last name.
Marcus James.
James, okay, Marcus James, from Michigan Works, and they're here to explain this organization.
Yeah, good morning. I'm Marcus James, and I am the Vice Chair of South Central Michigan Works. I've been in that role for about 13 years, also a resident of Jackson County District 5, and I'm here this morning on behalf of not only South Central Michigan Works, but I'm also serving as a chair for the team that's looking at the 5 counties, well, actually 6 counties. So it's the 3 counties that South Central Michigan Works represents: Jackson, Lenawee, and Hillsdale, but now also Washtenaw, Livingston, and Monroe counties. So what we're asking for and wanting you guys to take a look at is there's a consortium board that was formed in order to form South Central Michigan Works that included Livingston, Lenawee, Hillsdale, and Jackson. And I think Commissioner Alexander, Commissioner Leitner, and also Commissioner Palachik are on that consortium board. Well, what we're looking at needing to do now, the governor, well, first the Department of Labor. I need to pull up a presentation here that I have for you guys. Hopefully you did receive the cover letter and also the PA7 agreement that we're using, that we're recommending. The Department of Labor and also the state of Michigan have been requesting that we do look at regionalization. So the governor is pushing the regional prosperity initiative that goes across workforce development, economic development, adult ed, and transportation. And presently, South Central Michigan is being operated through a PA7 that you guys put in place. I think originally it was put in place back in 1984. Then,
Make this a little bigger.
okay. Well, originally it was put together in 1984 and then looked at again in 2000, 1999. So under that PA7 agreement, the consortium board was formed and South Central Michigan's workforce board was put in place that you guys were appointing members to that workforce board. What we're being asked to do now is to take that PA7 and expand that PA7 now to include the counties of Livingston and Washtenaw, and also make accommodations in there to add Monroe as well. So the issues that we're looking at right now is that we're going to need the county commissioners from each county to approve the PA7 agreement. And I'm not sure if everybody's familiar with the PA7 agreement. Okay, I'm seeing a nod of head. So the PA7 agreement that we're putting in place, we pulled out some bullet points, and I'll go through those in the next few slides. You have copies of the PA7. We're looking to get that PA7 approved by each of the 5 counties, but also by the governor's office by July 1st. So now we have a pretty short time frame that we're trying to get this done. So I wanted to make myself available this morning to go through that PA7, the bullet points, the key points, and answer any questions that you may have associated with that.
Marcus, if I could interject here, please. The presentation, I believe if you share with Mr. Brown, he can make it available on Board Docs. So we do have the proposed amended PA7 contract for us we have that. Yeah. But if, when you're done, that we have that as well. And I believe that will provide all of us the information we need.
Okay, thank you, Julie. The PA7 agreement has 13 separate articles spelling out the powers and authorities, and we'll go right through that. I'm going to skip over some of these slides and not take any more of your time than I need to. Articles 1 to 3 talks about establishing the PA7 and that it will include the counties of Jackson, Lenawee, Washtenaw, Hillsdale, and Livingston. Monroe at this point has decided not to sign on to the PA7. We have, as the group of people, we have some commissioners. We have Commissioner Cleta Smith that's representing South Central. We have a commissioner from Livingston and also a commissioner from Washtenaw, and who've been attending the meetings as we created the PA7. Monroe has chosen to remain with the Wayne County. They've been part of the Wayne County Alliance for a number of years, and even though the governor has designated Region 9 to include Monroe, at this point they're opting not to become part of this PA7. So the PA7 that you have in front of you does not include Monroe. Within Articles 1 to 3, you also have the definitions of the consortium, the new consortium we're talking about as far as the new Workforce Development Board. So what we would have is a regional Workforce Development Board that would include 5 counties now. And then there's just in Article 3, it's just talking about having the correct people sign that. Article 4 gets into something that's a little bit more contentious, and as I go through covering this with you, I would like to focus on those items that have been contentious as we've been meeting with the 5 counties and with Monroe being there as well. One of those is the liability, and what we're saying is that each county will be jointly liable based on population. And the agreement that's in place for South Central right now, when you look at Jackson, Lenawee, and Hillsdale, is based on population as well. Now, once we bring Washtenaw and Livingston County into the situation, if you take a look at Jackson, Jackson has about 19% of the population. Washtenaw has about 42% of the population. So in the PA7, when we look at liability, we're looking at Washtenaw having 42% of that liability. And this is for disallowed costs, for any disallowed costs that may occur. Hillsdale has about 5%, Jackson has 19%, Lenawee has about 12%. So that's going to be based on, liability will be based on population. Sub-grant recipients that we work with must hold Jackson hold harmless and have financial viability provisions just in case there are some issues with disallowed costs. If the agreement is terminated, the PA7, if it's terminated at some point, well, then any assets that we have within the consortium will be distributed to the partners based on population. Okay? So that's what's in Article 4. Article 5 is the service areas. No, presently, you're currently liable if there are disallowed costs within South Central Michigan Works, which is based on population, with Jackson having a much larger population percentage than the 19% when you just look at the 3 counties. So when we looked at, if you look at liability, there's presently liability, but once we have the 5 counties, that liability will be, I want to say it's smaller, but we're going from about, if we have the 5 counties, we're going from probably $4 million to $5 million that we're talking about coming from federal and state that's being used in our areas, our 3 county areas, to about $12 million that will be used in the total 5 county areas. So even though the percentage would be smaller, when you look at liability, we are talking about a larger fund when you talk about the entire 5 county region rather than 3 county region. Okay? We're putting accommodations into the PA7 that you have, that if Monroe County requests to join the consortium, that they can do so by just a majority vote. Any other county that may want to join at some point in the future would require a unanimous vote by the consortium. And then if the PA7 is amended to bring in another county, the governor has to sign that again as well. So each county will have to sign off, will have to agree that Monroe County can be brought in, and the governor would have to sign that again as well once we get this PA7 in place. So that's basically Article 5. Article 6 basically establishes the board of the consortium. The consortium board will consist of 10 members. They will all be county commissioners. Even though we have some disparity in population when you look at the 5 counties, what we've decided on as a team is that we would have 2 commissioners from each of the 5 counties who make up the consortium board. So we would have we would have equal representation for the larger counties and the small counties, but there is an allowance being put in the PA7 that would allow, on exception, voting to be based on population. So if 3 members of the consortium decided that there is an issue that needed to be looked at differently than the equal representation, 3 members would have to determine that, would have to call for that vote being done by proportion based on population, and there's an allowance in there to do that. Okay. Article 6 also spells out the roles of the chair and the vice chair, and also some deals like meeting quarterly, the quorum, and then there's an annual report that that consortium board will need to give to the 5 county boards once a year. So that's Article 6. Article 7 talks about powers and responsibilities of the consortium board. The new consortium board, the expanded consortium board, the 5 counties would also now need to put a new workforce development board in place that will also cover the 5 counties. The consortium board would serve as the local grant recipient, and you're presently doing that right now for the 3 counties. You're the local grant recipient, but you've appointed a sub-recipient. The Hillsdale ISD is presently serving as the fiscal and the administrative agent for the workforce work that's going on in this area under your direction, under the consortium board's direction. And that will be the case with the new one. You'd also have oversight of the workforce development board budgets and program activities, and also have the power to enter into contracts and put insurance policies and that kind of thing into place. Basically what you're doing right now for the 3 counties, the larger consortium board will continue to do for the 5 counties. The consortium board does not have the authority to levy any type of tax, and also the consortium board does not have the right or the authority to take on any debts or liabilities for any individual county without that individual county giving written consent to do so. Okay? Article 8 basically talks about the Workforce Development Board. So you can look at Article 8 and see what the Workforce Development Board for that region, for the 5-county region, will have responsibility for. But basically overseeing ongoing administration of the Southeast Michigan Consortium. So that's the name that we're using because the governor called Region 9 the Southeast Michigan Regional Prosperity Region. So we're calling this the Southeast Michigan Consortium rather than South Central Michigan Consortium. So they would, the Workforce Development Board would be over administration of the workforce programs, including oversight of the administrative entities and subgrantees. The members would be appointed in accordance with the Workforce Innovation and Opportunities Act. This was the new act that that was signed into being back in July of last year by President Obama, that took the place of the Workforce Investment Act. And we'll also make sure on the Workforce Development Board, you're required to have no less than 2 members per county. So every county will have at least 2 members on that Workforce Development Board. The consortium will try to maintain proportional representation of the private sector on the board, and also the Workforce Development Board cannot incur debt, liabilities, or obligations, including any pension obligations that extend beyond 1 year without the consortium board's express formal consent. So that was another contentious item that we worked through. Article 9, the consortium board can subcontract the administration and fiscal agent duties required for federal and state-funded employment and training programs, but the subgrantees must certify that they have the ability to repay disallowed costs, and also will have to execute a hold harmless agreement with the consortium board or the Workforce Development Board if we're going to utilize them as a subgrantee. Article 10 is just a non-discrimination clause. It's pretty standard, but that's there for you to take a look at if you want. We took the most liberal one that we had in the 5 counties and adapted that one. Article 11 was severability and amendment. If any part or section of the agreement is found to be invalid by a court of law, the remaining section shall remain in force. And also the PA7 agreement can only be amended by consent in writing of the counties. Similar to getting this in place, we need approval from each of the county's Board of Commissioners. And for an amendment, we would need that as well. And then we'd also have to get approval by the governor of the state of Michigan to get the new PA7 or the amended PA7 in place. Article 13, I think is the last article, duration and termination. The agreement will be effective as soon as it is approved by all 5 participating counties and the governor. The Jackson County Commissioners are the first group of commissioners to take a look at the PA7. We have additional meetings this week in the other counties, this week and next week. And hopefully we'll get that approval by the Board of Commissioners. And once we have that, then it will be sent to the Attorney General's office for approval and final approval by the governor. Okay? The agreement, the PA7, will remain in effect as long as the Workforce Innovation and Opportunities Act is in place. And then any county which is party to the agreement can withdraw from the consortium with prior written notice of 120 days before the end of the consortium's fiscal year. So the next steps final slide, is that we need the counties to review and approve this new PA7 that will now include Livingston and Washtenaw. Get the Attorney General review and approval. Once that's been done and the governor has signed off, then we'll need each of the Board of Commissioners to appoint 2 members from your counties, from each county, to the new consortium board. Now, once the new consortium board is in place, that new consortium board will put the new Workforce Development Board in place, and we'll do the determination of the administrative and fiscal agent. Okay. Any questions? I know you, yeah.
Marcus, what direct impact will this have on our community as far as the services that South Central Michigan Works currently provides?
Yeah, the only, as from a human resources standpoint, how it will change the organization and that, that's going to all be worked out as we're looking at, as we get the new Workforce Development Board in place. But we don't anticipate any changes other than the main reason that this is put in place is to allow more collaboration between the various counties. So we still have, right now, everything that we have in place today, we still plan to have in place as this new PA7 is put in place. So the one-stop shops and how people come in and get their services and all of that, all the employees we presently have right now will continue to be there the day that this is signed. Now, we have a service delivery group, and our executive director, Sarah Hartzler, is on that team. They're looking at how they can, right now, we don't have the possibility of moving funds from one county to another, and with this new agreement, we can do that. So if we have extra funds in Washtenaw and we need those to help people here in the Jackson community, once we have this in place, this new organization in place, we can move those funds without having to send them back to the state and then request them. So the 5 counties will be able to move funds, from place to place to assist.
All right, thank you. And I understand that you're asking then for us to place this on, go through the June process, which would mean it would go to Agencies and Affairs next Monday, and for further conversation and approval, and then it would move forward to the Board of Commission for a full vote. Is that my understanding, Commissioner Leitner and Palachek? Is that the way you also see it?
Okay. All right, yeah, that's what we're asking for. And once that's done, if we get your approval, once that's done, as well as your other colleagues in the other counties, then we'll send that to the governor's office, to the attorney general's office.
And thank you for your PowerPoint presentation in which you simply brought up the concerns that people have had. That was helpful.
Okay. All right. Thank you.
Excuse me,
Sure.
are there any other questions? I did have one question.
Sure.
You spoke of liability, and when I think of liability, I think of ultimately some costs, and you talked about 19%. Currently, we provide no money in our budget for this activity. Should we anticipate some costs?
No, the liability, really all the funds that we receive, they're either coming from federal or state, and there are stipulations on how those funds can be used, whether, as we do training for incumbent workers, dislocated workers, youth, whatever. And if it turns out we're using a service provider, and they use some of those funds that comes from federal, say there's 10,000, 20,000, 100,000, and they use those in a way that are contrary to the restrictions that were put on those funds, then that service provider is the person that's on the hook for paying those funds back to state or federal. So they're on the hook for that. But if for some reason they are not able to do that, and that's why we have the hold harmless, and we also have the system where we look at their financial viability and that kind of thing. But if they can't do that, and say there are some disallowed costs, at the end of the day, that's going to come back onto the fiscal agent. Now, right now, for the South Central Michigan Works, the fiscal agent is the Hillsdale ISD. So if there's something that comes up right now with the consortium and with South Central Michigan Works, that cost will go to Hillsdale ISD. They would have to provide those funds back to state or federal. And if for some reason Hillsdale ISD couldn't do it, it would come back into the purview of the 3 county commissioners, 3 county board of commissioners. And that's going to be the same situation with the new consortium. So I don't see where there's a need to have additional funds. It's going to be working similar to the way it works right now, but it does behoove us to continue to be very adept at taking a look at the ability of these sub-grant recipients we use and choosing a good fiscal agent and making certain that they have everything in place. And there are audits that are done on an annual basis, also probably audits that are done even more so than just on an annual basis to make sure that all that's taken care of properly. So to answer your question, I don't see that we would, the commissioners would need to be putting anything in your budget different than what you've been doing for the last 20 years.
Marcus, real quick, if I may, we haven't had disallowed costs. We have not had issues with
No.
disallowed costs in our organization, so we don't believe that that would be something to be of concern. As long as we follow our policies and guidelines, we don't fall under those disallowed costs, and we are very stringent with how we follow our policies and guidelines. So,
Yeah. The biggest difference will be for Livingston and Washtenaw counties. Presently, since we have a consortium board in place and you have representatives on that consortium board, everyone in the organization understands that everybody reports to the consortium board and our fiscal agent, administrative agent, Hillsdale ISD. For Livingston and Washtenaw right now, all of their organization within their workforce reports directly to the Board of Commissioners. So they will have to do some things differently, but pretty much everything that's been done for South Central, for the consortium board and everything, we're basically taking that model that existed for Jackson, Lenawee, and Hillsdale and expanding it to include Washtenaw and Livingston counties. Per the governor's charge, yes. Yes, Mr. Chairman?
Commissioner Shotwell.
Obviously, you've done a very good job on paying attention to disallowed costs, and you're asking us to partner with two agencies, two other counties. Have they behaved themselves and be able to follow the rules on disallowed costs?
Yeah, in the discussions we've had, they have not had any issues with disallowed costs either for the, for the amount of history that they could, were willing to share with us. So they also are having audits. They have an executive board in place similar to what we have. And as far as we can tell, they have very good fiscal responsibility as well.
Are there other questions, commissioners? If not, I just have one clarification. So the expectation is that we will move from 3 commissioners currently serving to 2 this month? No.
No, it would not be this month. Well, once the PA7 is approved, so if the PA7 is approved, say July 1st, which is the target date we have, at that point, then we will have to start putting that consortium board in place. And at that point, we will have 2 from Jackson, 2 from Lenawee, 2 from Hillsdale, and 2 from the other 2 counties. So it could be, Julia, it could be as soon as July, mid-July.
So July or August meeting, something
Yes.
to that effect. Okay, thank you.
Yes. Okay. All right.
Let's see. Next up, we have the Human Resources. I believe Joni and Richard, one or both, are going to take us through the changes to FOIA effective July 1st.
Good morning. I wanted to introduce myself. My name is Richard Martinchuk. I'm the new Director of Human Resources. Started on May 18th, and today we're looking at an amendment made by the state legislature to the Freedom of Information Act. From a high-level 10,000-foot view, basically this is about fees and costs, about making forms available on the internet and in hard copy revised forms. And also, it seems to codify an appeal process for excessive fees that someone could appeal. So with that said, Joni Johnson has worked with outside legal counsel and some other associations. They've vetted the forms, and it's in your board pack. And she can take you through the details of those, and we can entertain any questions at that point. So thank you, and I appreciate your time.
I'm going to apologize up front because I have a respiratory thing going on, so I'm going to try and get through this without coughing my way through it, so forgive me. You do have, I know, a lot of information in your packet today, so I'm going to go through kind of a summary of what the amendment entails and what you have. The FOIA was amended to be effective July 1st under the Public Act 563 of 2014. So the statutory amendments affect the fees that can be charged, the documentation that must accompany a request, and any penalties that may be imposed. There's new statutory provisions that allow a requester to challenge fees charged. And most changes in the amendment favor the requester, and it does put an increased administrative burden on the public body. There are quite a few documentation changes. To charge a fee, we have to establish and publicly make available free copies of procedures and guidelines to implement the process. We have to include use of a standard form with detailed fee itemization. So that's really gone from a very simple one-page to a 7-page form. We have to create and post on our website written public summary of the procedures and guidelines, and they have to include how to understand the public body's written response, deposit requirements, fee calculations, and avenues to challenge and appeal of the fees. And then the public summary must be included in the FOIA response or reference to the website link. As far as the detailed itemization of the fee components, which has made the fee statement significantly longer, it has to clearly list 6 allowable charges, and those include the labor costs for searching, locating, and examining the records requested, separating exempt from non-exempt information, actual and most reasonable cost of providing records on non-paper media, the actual cost of duplication, labor costs with duplication or publication, and then the actual cost of mailing. And then there's other detail included on waiving or reducing fees. As far as the appeal of the fee calculation, the amendment now allows for challenges to any fees that are charged. And in one of the conferences I went to, they actually recommended that you, unless it is a significant amount, don't even charge fees, because you're just opening yourself up for an appeal. The individuals can appeal to the head of the public body or commence civil action in the circuit court, or on appeal, the head of the public body has the option to waive, reduce, or uphold the fee, and the circuit court can either uphold or reduce the fee. And then there has been a change in the civil fines as well. Fines imposed by a court if an entity refused or delayed disclosing the documents has been increased from $500 to $1,000. And if the court found that there was willful or intentional failure to comply with the request, they can impose fees ranging from $2,500 to $7,500. So in your attachments, you have several things. The FOIA procedure and guidelines, that would replace the current policy 5440, and that's part of the resolution. You have the public summary, which is now would now be required, and that would be posted to the county's website, along with the operational procedures. And then the cost itemization is in your packet, and that would be used going forward July 1st and would replace the form that has been used for the past several years. And then in the forms packet attachment, those forms either replace or add to existing forms that we've used in the past. So because the amendments go into effect on July 1st, if we don't have these in place, we are prohibited from charging any fees until we do comply with the amendments. I think because you have the background and the current situation, if you have any questions on that, I'll try to answer them as best I can.
And this will be going to committee and to the full board on, 2 weeks from today?
Yes.
Any questions at this time? Seeing, hearing none, thank you, Joni.
Thank you.
Next up, we have the Leone SRI default resolution. I'm going to take a little time here and visit with some of the history here. refresher for some of the board members. Of course, we have at least 2 members, I don't believe, who were here last time this all came about, last year. Let me preface my remarks by saying that I've been involved with this now for 2 years, and of course this goes back to '04. So, frankly, I don't have all the, dare I say it, but I will, animosity that seems to have developed over the years in regard to this bond contract, this whole event. For me, it's about trying to be equitable, but frankly, I'm trying to even remove some of that from my position. I'm just trying to look at what the judge said, really, because that's really, at the end of the day, that's, in my mind, where it comes down to. But let's just say, going back in the early 2000s, if you recall, the world was a different place. Housing market was doing very well, and there was continued expectation of it to continue to grow and move forward. With that said, and I've heard lots of things from all these different people and read lots of different things, and everybody has an opinion of how this all started and why it started and who's to blame and all that. At the end of the day, the deed is done. Now we have to pay the bill. So back in the early 2000s, they decided that there was need, and it makes sense, to provide sewer around the lakes down in Hanover and Liberty and the like. No one wants septics failing and that material moving into the lakes. Makes sense. Expected growth, so should be not a problem paying for it. Well, we know what happened. Housing market has crashed. Growth never appeared, materialized. But yet the SRI went forward. It was installed prior to that. There's a bond contract that's roughly 30 pages long. Frankly, I'm not an attorney. I think it's a train wreck, because when I'm reading through it, one part says one thing, and then I get to another part, and it says something else. And it's like, so initially I'm reading, I'm going, oh yeah, here it is. These people have to pay. Then I read a little further back, and I'm like, no, wait a minute, those people have to pay. It's not contradictory, but it evolves through the whole contract as you read through it. Again, not an attorney, but I've read a lot of contracts, and this one here I struggled with. So with that said, what I want to do is, before we actually talk about the resolution, I want to kind of review the judge's disposition, his order, Judge LaFlamme, which goes back to, he ruled in October of 13. So given that it's June of 15, I'm thinking that most parties must either feel it's correct or there's no cause for appeal or something, because no action has come out of that, at least not that I'm aware of. And I did make that available to everyone, so it is on board docs, it's available to the public. I will also make sure that the Plant Moran final document goes on board docs, so it's available to publicly. It's a small document, a few pages long. Looking at the judge's order here on page 2, and I'm not going to read this whole order, it is rather concise, about 8 pages long. I'm just going to read snippets here and there that I think are material to what ultimately he found. Page 2, he says, the townships argue, and I should say that when he says townships, he means Columbia, Hanover, and Liberty. He describes that, defines that on page 1. The townships argued that the bond contract requires Leone alone to pay the debt service on the bonds, or alternatively, is ambiguous as to who should pay, creating a question of fact, he says. That's what the townships argued, those 3 townships. But the judge goes on to say, next paragraph, the bond contract, read as a whole, not just the first part, does indeed provide that all revenue for the payment of the bonds come ultimately from the townships. And recall, as the judge defined the townships, he defined it as Hanover, Liberty, and Columbia on page 1. So when you flip on back through here, we'll skip some of this other bit of business he's got in here describing parts of and elements of the contract. To page 4, he says, and he says it in bold, I might add, the townships covenant that should it appear upon notice from Leone, Columbia, or the county that additional funds will be needed to pay the expenses of the operation, maintenance, and administration of the system or debt service on any notes or bonds when due, the townships will promptly increase fees and charges for the use of all system facilities or provide such monies from general funds so that the sufficient revenues will be available for such purposes. Skipping a few more pages because he starts talking about rules of construction and things like that. I'm going to go to page 6 for those who are following along. He says on page 6 here, and there's a number of things here I want to speak to just for the benefit of those who may not have this document in front of them. It says here, talking about rules of construction, applying the rules of construction, the court concludes that the bond contract is not ambiguous. From a layperson like me, I read it and go, I think it's a little ambiguous. Trained attorneys, trained judge, not so ambiguous. The provisions which speak to Leone's obligation to make bond payments speak only to Leone's obligation as a primary pledger of its full faith and credit to the county to assure that all bond payments are made. Because there's been a lot made, I've been told a number of times in the beginning of that contract, well, Leone pledged their full faith and credit, so they have to pay. None of the provisions that obligate Leone to make these payments speak to the ultimate source of funds to be used. You have to continue reading through the bond contract. Next paragraph. The intended ultimate source of the funds used, or to be used, to pay the bond debt is the users of the system within each township. This is the judge talking. However, the bond contract itself does not anywhere obligate the townships to write a check to Leone simply because the amount of the connection fees falls short of the amount to pay the bonds. Next paragraph. Paragraph 15, he says, he's referring to the contract. He says, paragraph 15 of the bond contract requires the townships to establish fees and charges to persons using the system upon advice from the board and or Columbia as to the amounts necessary to operate and maintain the system. Establish appropriate reserves and pay debt services on the notes and the bonds. By this language, the bond contract clearly contemplates that the townships will pay for debt service charges through fees and charges for services to persons using the system as the primary source for paying the debt service. Going to page 7, the judge continues in regard to paragraph 15 of the bond contract. Paragraph 15 of the bond contract further grants to the county the right, after conferring with Leone and the townships, to direct the townships to raise such funds should it appear to the county that additional funds would be needed for such purposes. Next paragraph on bottom of page 7. The court's reading of paragraph 15 of the bond contract as reserving to the county the sole authority to direct the townships to raise additional funds is reinforced by the default provision of paragraph 19 of the bond contract. And that's when he starts referring to MCL, Act 185, state law. And he says right at the very bottom of that there, says, townships under this contract, including the obligation of Leone and the townships to make all payments in the manner and at the times required by the contract, and the right to direct Leone and the townships to make a tax levy or rate increase, reimburse the county for funds it may spend. That there clearly the judge is saying that if the county has to make the payment, we can direct that these townships reimburse us. Again, I wanted to just say in regard to the judge's opinion, because at the end of the day, I think at this point the only thing that really counts and matters is what the judge has ruled. If we disagree with the judge, well, we can appeal file another lawsuit or something. But the bottom line is the judge ruled that if there's a default, if we believe or deem that there's not money available, default would qualify, that we have to decide how it's going to be paid. Obviously, the county, we would not want to let the default stand. We have to make this bond payment come July 1st. The overall economic well-being of our county, is dependent on these type of activities. As many of you know, we've been having conversations with the EG about shovel-ready and infrastructure and all those kind of things. Well, our credit rating and good name goes a long way too for potential economic development. It doesn't serve us well as a county when a potential investor or someone who wants to relocate a firm or start a new firm reads in the newspaper that we're squabbling and quarreling amongst ourselves over something as fundamental as water or as sewer in this particular case. We really need to resolve this issue and move forward with this. Now, as far as the Board of Public Works yesterday, they did modify the resolution that I had brought forward, and so you do have that in front of you today in board docs. Frankly, it's not my intent to determine who pays what today. My intent is to declare that Leone is in default and provide them notice that within 10 days they need to make payment. Per the bond contract, in 2 weeks we'll have our Tuesday night board meeting. In 2 weeks is when I hope to bring, or I will bring, an additional resolution that will spell out the alternatives, perhaps the recommendation as to what I think we should do. And although I am prepared to speak to that somewhat today, because as I said yesterday to the parties that were present, most of the townships were here yesterday, what's really, I believe, in the best interest of the townships and frankly the county as a whole is if these townships get together and decide what is fair and equitable amongst themselves. Because if the county has to do it, one, obviously it puts the county commissioners in a difficult position because, not all of the commissioners reside in those townships. And yet at the same time, we're supposed to be acting as somewhat the judge, if you will, on what's fair or not fair, that sort of thing. I think the people who are directly elected to represent that particular township, meaning that at the closest level, which is township officials, should be making this decision on this. And just so to help you with some of the math on that, I've done some of the math. And I annualized it because while July 1st is a bond principal and interest payment due, there's also an interest payment in December. So you add the two together to get your annual, what it will cost. And, obviously it's the contract as well as Act 185 speaks to a number of ways that we can raise these monies to pay the debt, one of which is an ad valorem tax. For those who may not be familiar, a tax of that sort it's a property tax. It goes across everyone in the township, everyone in the township, not necessarily just users. So you may be miles removed from the actual sewer itself and paying for it. Based on the outstanding annualized debt, in this case here for 15, it's $405,000 and change. You need a millage rate somewhere between 0.4 and 0.7. For a home that's, say, a $100,000 home, that's roughly $20 to $30 plus dollars, right around there, annually. Remember, though, you may not even be hooked up to the sewer. And it only goes up, obviously, the more value of the home. If you were to look at the fee side of it and say, well, it's not fair to charge folks who aren't hooked up to the sewer. We should charge people who use it. They're the ones directly benefiting. Okay. That makes logical sense, right? That's what the contract referred to. That's what the judge has referred to, users. But, as has been said, there's not a whole lot of users. If you look at the REUs, there's only 573.14. Not sure how that works, but that's 573 REUs. That works out to $707 per REU. If you're a business that has multiple REUs, that's a substantial sum pretty quickly. If you're a single-family homeowner, still $700, that's what, almost $60 a month increase to pay this if you go look just at users. Well, that doesn't really feel right either, in all honesty. So it's a difficult situation. If you look at how the users are dispersed across the townships, you come into a whole nother sense or equity issue, in that, as has been said, Columbia has 5. This really, and obviously all this is my opinion. When this was built, it really wasn't about Columbia. It was about Hanover and Liberty and those lake properties, and some of the lakes that haven't hooked on that probably, well, we'd all be better off if they had, through cost as well as environmentally, I would suspect. So Hanover has 422 REUs, Liberty 125, Columbia 5. So if you go from a tax perspective, well, Columbia is going to be paying a significant amount for 5 users, if you go from a tax perspective, because Columbia's taxable value of that township is actually greater than Hanover and Liberty's taxable value combined. So they would paying more than half for 5 users. I have equity issues with that. But by the same token, you know, if you look at just the users, Hanover, which is Hanover, you know, and Liberty, again, a fraction of the taxable value, have the most users, and it puts them in a difficult situation too. Hanover's obligation becomes annually $298,000 just for Hanover, if you look at it from a REU user perspective. So there's some difficult decisions there, and I've talked to the parties. I know that would be very much a difficult financial burden for the township to assume, because that is an option. The township can say, you know, we're not going to pass that cost on to our user or resident at tax. We're going to pay it out of our monies that we have already accumulated in our general fund. Well, how many years you can do that? Maybe one, maybe none. Depends on what the balance is of their general fund. So there is some significant equity issues here to be determined, and I personally believe that it's in the best interest of the 4 townships to get together and figure that out before July 1. Because once we make the payment, frankly, in all honesty, in 2 weeks, I think you need to have it figured out, because in 2 weeks, the county commissioners here really, you don't have to make a decision at that point other than, you know, that we will make the bond payment. Because it's not like if you make the decision in 2 weeks, the money is going to come forth. You know, it still takes time to increase a tax rate or user charges, and that money to be accumulated and collected and reimburse the county for that. There's been much made of Leone. This is going on since, what, 10 years? I actually have a schedule here of bond payments. Leone has, if you go back here, in 2005 there wasn't a bond payment. In 2006 is really when they started. And when you look at the bond payments here, Leone has paid, and I do not understand why Leone has done this. They did, for whatever reason. But they have paid in excess of $2.4 million on a bond that they have no users. Now, I'm not sure why they did that, or even if they should have done that. Frankly, if I were one of the township people in Leone back in 2006, I would have argued that that's not what the contract says, and we shouldn't have done that. And the judge would have agreed with us. But the fact remains, they paid over $2.4 million of bond debt thus far. Now, it's been suggested by Leone that I include that calculation into what is outstanding on bond debt. and add that in and therefore reimburse Leone. The contract, and I've discussed it with counsel, legal counsel, the contract doesn't allow us to do that. The contract basically says, if the bond payment is not met, we need to meet it, and then we can reimburse ourselves. So it's not up to the county to make Leone whole. That's a burden Leone has on their own. But I don't want to necessarily lose sight of, Leone has paid $2.4 million on this bond, which the judge said should have been paid by the users. Whether they ever reimbursed by that, that's not for us to decide. So back to the resolutions. The resolution I proposed basically says that we declare Leone in default. The resolution that came out of the Board of Public Works says that we declare Leone in default and tax them exclusively for the payments of the bond. This was brought forth by the Drain Commissioner yesterday, ultimately approved. And I will just read it, this last one here. I do not recommend this at this time in particular, because right now, for me, it's about declaring default and moving forward, and then we'll figure out who's going to pay what. But it says here, be it further resolved that Leone Township is directed to levy and collect an ad valorem tax in the amount owed, including interest and penalty, less the amount received from the state pursuant to MCL, and to make such payments to the County of Jackson. I personally believe it would not be appropriate at this time to declare default and pass sentence that the taxpayers in Leone Township alone are responsible for the bond payment on the SRI. Questions? Anyone? Dave had a question.
Dave, if I may first, please. In defense of my resolution, I refer commissioners to page 6 of the judge's opinion. Continuing with applying the above rules of construction, the court concludes that the bond contract is not ambiguous. They simply mean that Leone must make all of its revenue available to make sure no default on the bonds, consistent with the pledge of full faith and credit. That's the sentence that you didn't read when you were reading your underlying documentation, and that's what I based my reason for the decision in the resolution change. It wasn't a politically driven item. It's an item that's placed before me by a judge in his opinion. That's the reason why I made the amendment.
Mike, I guess I'll work backwards. I agree with almost everything that you've said. One of your comments, though, was that Leone has paid $2.4 million since, I think, 2004, and yet they have no users in the system. I disagree with that. They have users, but they do not have any taxpayers in it. Fair? They've got users of the Leone, of the sewer system that are coming from primarily Hanover and Liberty. That sewage is being treated at the sewage treatment plant.
No, that's not how we define users for the SRI. Users are people who are actually hooked up to the pipe that is the SRI pipe. There's users across 13 municipalities. But for the SRI purposes in the courts, the users are the folks whose sewer hooks up to that particular piece of pipe.
But if not for the SRI, those users that are in Hanover and Liberty would not be sending sewage through Leone's treatment plant that's being treated, correct? Okay. So I go back and I have read pretty much all the documents that you put on board docs. I had most of them ahead of time, including the judge's opinion, the contract, and some other documents. And I'm glad the chair pointed out the one thing that he pointed out, because I agree with that. And I also looked at page 3 of the judge's ruling where the court has added emphasis to it, and the added emphasis part says, Leone shall be required to pay such amounts from any of its general funds as a first budget obligation. I think it's clear, probably to everybody here, that Leone is the one that's supposed to be paying the bond payments to the county. Now, what's in question certainly is where that money comes from. I don't think that's a fight for us to have. I agree that they should be working that out. But it's abundantly clear that Leone is to be paying us. The next paragraph is on the same page. The court has added emphasis again. It says, the emphasized part, it is the intent of Leone to pay its obligations under this contract from the revenues of the Leone Township sewer system. I don't think it could be clearer, and he's deriving that from the bond contract, but the court has added emphasis to that. And I'm glad you provided those numbers and did your math on everything, because it's a pretty telling story that I don't think if we were to have to decide how to figure out where the payment should come from, what could be the equitable way? I mean, you talk about the townships being, I guess, primarily Hanover and Liberty using their general fund to make that payment. Well, that is still taxpayer money for every resident in those townships. And how would that be fair? On the same note, how could you expect Hanover to pay $298,000 annually, and you're talking about $707 per user annually? So one of the questions I wrote down, and I know the answer to it already, is who will own the Southern Interceptor when it's paid for? And the answer to that is Leone. So why would the residents of those townships want to pay for part of the delivery system to send their septage to the Leone treatment plant that they're going to have to continue to pay service charges on forever, and yet they don't own it, but they're going to have to pay for it in that huge amount? It only makes sense to me that the assumption by the citizens that are paying this is that they were paying it through their user charges. And I don't think you can argue that that's what's happened up until now, with Leone having paid $2.4 million since 2004. They would have had to have paid that from revenues into the system, which I think is probably the way that it was designed. I also agree with what you said clearly about this fight or issue being an obstacle to economic development. I think that couldn't be farther from or couldn't be more true. But I think really what you need is, in this case, they need to work it out, but I think that people should be thinking more county-wide. We have 2 sewer systems in this county. There had been prior talk by all these townships of an authority that would run the system, decide what's fair, decide what's right, and that made a huge amount of sense. It makes more sense to me that there should be a countywide authority potentially putting both of those systems together so they're not in competition with each other. We've got we've got 2 public utilities, really, the city sewer system and the Leone sewer system. They're sometimes in direct competition with each other. You have, I think anyway, some Blackman residents who I represent that are served by the city system. I think there's a few that are served by the Leone system probably. And it just makes more sense when we're talking about taxpayer dollars and the residents that we represent to be thinking county-wide on this issue when it's a public utility, for them to be sitting down and finding a way to make this system work better and really to spread the cost over. You have economy to scale when you would put these 2 systems together. And I'm not even talking about, how the systems are run. You had mentioned, Mike, that there's a potential there that we could appeal. We're not even a party to the lawsuit. We can't appeal it. Right, okay, the townships could. I recall in the judge's opinion that he was looking for additional briefs from the parties, which I believe he got, but I saw no further ruling from the court, and it seems like there was another ruling that probably should have been pending from the judge, maybe on some of these other issues. But for me, it goes back to one simple thing, or 2 simple things, really. I agree with you that those parties should be figuring out how this should be. 3 things. 1, it should be Leone that's making the payment to us, and then them working it out. And 3, I think, economically and for the benefit of our residents of the county that we represent, I think that all these parties should be encouraged to be looking at a countywide authority that would govern these systems and better serve the residents of the county. Thank you.
Other questions? Mr. Duckham, Commissioner Duckham.
Yes, thank you. Well, as representative of Columbia Township, I don't see. I had some difficulty seeing how they're even almost part of this. They, in my vision, were gracious enough to be part of the entire system and do something that benefited the entire system. Liberty, Hanover needed the sewer system hooked up. And Columbia agreed that you can bring the Southern Interceptor and intersect at in Columbia Township and then ship it all via the Clark Lake lines through to Leone Township. Columbia clearly didn't need the Southern Interceptor. They've only got 5 users. And those users probably would still be using septic systems had it not been for the Southern Interceptor going right through their properties or in front of their properties. So for the greater good of the entire system, Columbia allowed the Southern Interceptor to intersect, I believe it's the Clark Lake Equalizer Basin, so it would be cheaper for the system as a whole to get everybody flowing into the sewage treatment plant in Leone. And because of their graciousness of allowing this Southern Interceptor to intersect in Columbia Township, they're being drug into a multi-million-dollar obligation for 5 customers. I don't even know. It don't make sense to me why that because of their willingness to help others that they're drug into such an obligation. I mean, they could have said, no, we don't want it to flow through our township, and the only way that the people that did need sewers could have hooked up the Leone system would be to construct a second line all the way to the Leone Township water treatment plant. But because they allowed it to come into a line in their township, which makes sense, they're drug into this multi-million-dollar issue. Secondly, I have everybody I'm sure here knows me, I own a trash hauling company. And I have sometimes trouble taking my business cap off and thinking in terms of public service and political issues. But if I want to expand my business, I buy dumpsters. And I set them in my yard and I wait for people to call and say, I want your trash service. I don't say, okay, you have to buy my dumpster, and then I'll pick your trash up and dispose of it properly for you. I say, great, I want more customers. I've bought the equipment to expand my business, and it's sitting in my yard, and I'll put it in your business, and I will charge you X amount. And that really includes the cost of the dumpster, because it's really not free. It's built into my cost of providing your service, and it's a business decision I make to expand my business. And I liken that to Leone Township saying, we can expand our business to your township, Columbia or Liberty or Hanover, and offer your people more service, service you need, or service you want. And that it's part of my business plan to get more customers so my cost per unit is less for the entire system. And I certainly, trying to run a parallel thought here, I take the gamble, I take the risk, I put the money up front to buy a garbage dumpster to give you the service you want to pay me for. I don't sell them, I provide them. And in my mind here, it's, we got 2 townships, Leone and let's just say Columbia, that says we okay, we like your proposal to treat our people's septic systems. You put the line in, and we'll pass an ordinance where everybody has to use it, for the good of everybody. And I have a hard time sometimes separating the business aspect from the public service aspect. It seems to me like if Columbia, Liberty, and Hanover provided that ordinance and the customers for Leone to treat their septic residue, that the lines connecting would be paid for by the system as a whole, and the treatment cost would go down for the system as a whole because you have more REUs for the system to treat. So, just my thought.
First off, I appreciate all the comments that are made here from everybody, including during public comment, as well as my fellow commissioners and the county administrator. And it's quite apparent that what we really need here is something that's fair and equitable. The contract, let's put it this way, I've read the contract. Mr. Thompson is definitely correct. I shouldn't have read it twice. I don't know why I did that. But anyway, it's very convoluted in many ways, that contract. So what happens next is you have a judge, Judge LaFamme, who takes the contract, and I'm sure he used some of his staff to go over the contract, some of his legal experts and aides. And he takes the contract and he finds it unambiguous, which means he finds it clear. And if you look at the ruling, as our administrator says, and if you and listening to our administrator's recommendation, our administrator, as Commissioner Elwell stated, is right on target. The judge is very clear. It's not even a maybe, a possibility. And for us to sit here and try to understand how the judge came up with an unambiguous, clear understanding of this, I'm not going to tell you how he did that because I have no idea. But he said he did. And when you look and when you read that, he did refer to townships, just like, the board can be referred to as the Board of Commissioners. So in this language, as we move forward, when you read the word board, it means Board of Commissioners. Well, he did the same thing here in essence. Townships referred to Liberty, Hanover, and Columbia. And to speak to Commissioner Duckham's comment, Columbia was not dragged into anything. This was a contract that was put together. This was a contract that was signed, and Columbia was part of signing that contract. Columbia Township, like anybody else, just like Hanover and everybody else, Liberty, Leone, even the county, have attorneys and so on and so forth that back in the day had an opportunity to thoroughly look at the contract as we have now before signing it. And they signed it. So now you go back to a contract, whether we like it or not, the contract has language in it that the judge has said, this is what it says. And the judge has clearly said that 3 townships are to pay Leone Township, and we are all correct, Leone Township is to pay the county. Okay, that's right there in the ruling. And in some ways, I think maybe the judge kind of knew we were going to get to this point, and I think, from my perspective as a commissioner, the judge put us in a position that he should have never did in the first place. Quite frankly, he should have made the decision, and because as our administrator said, and I totally agree, he's made us judges as opposed to legislators. But the problem I have with this too is, the judge, in some ways, maybe the judge felt that this would end up back in court because he did make a comment that he thought he would see people back in court again. And my biggest concern about this whole thing is that, when when you talk about system and users, the fact is, Leone Township does not use the Southern Regional Interceptor. They do not use it. It's used for the townships that are hooked to it. And another part of this whole thing, too, we have to keep in mind, when you talk of the system and when you talk of the SRI, that's two separate things, okay? The system involves 13 municipalities. Trust me, those other 9 municipalities who are not part of this don't want to be part of this. And we don't want to even begin to think about them having to pay anything. When our drain commissioner suggests that, or Plant Moran suggests that there's enough money in the system, well, that includes those other 9 townships. That's because those other 9 townships are users. They also pay for their own system that they have connected to, just as Columbia, Liberty, and Hanover have a system that they are connected to. The question is, why is those other townships okay with making their bond payments, if you will? So they shouldn't be making their bond payments either? Just a question I'm throwing out there. They shouldn't make their bond payments either, so we should throw that contract out the window too. Well, again, if we're going to be fair and equitable in this whole thing, and we're going to look at this, and we're going to realize this contract, like I said, is convoluted, it's in some ways a mess. Well, at that point, we have to go by what the judge has ruled, from my perspective. And the judge is very clear if you read the ruling. And I just really struggle with the fact that we talk about being drug in, we talk about this, we talk about that. No, that's not true. When this contract was signed, people signed the contract, okay? If they didn't read it, if they didn't have attorneys look at it, that's not Leone's fault, that's not Hanover's fault, that's not Liberty's fault. Matter of fact, it's probably nobody's fault pretty much in this whole room, because I don't think anybody was dealing with it much back then, except for maybe Supervisor Tellis might have been involved. Oh, you too, Mr. Thompson. Okay, so, you know, for me, we have a contract that the judge has said states exactly what our administrator said. We have Plant Moran that says Leone Township does not have enough money coming in to make the SRI bond payment. It says it does have enough money in the system, but the system involves 13 municipalities, just keep that in mind. And we cannot, and Leone cannot take money from the system or from other 13 municipalities. Okay, that makes no sense. So you have a contract, a judge telling us what the contract says. You have Plant Moran telling us that there's not enough money in SRI bond. You have our administrator who has conferred with counsel and talked to everybody in this room probably. And our administrator has even said, let's take this and move it forward. Okay, yes, Leone has defaulted. The reason Leone has defaulted is because the county says you need to default before we can do anything. They didn't default and not make the payment just because, hey, it's just default and not make the payment. They defaulted because the county said you need to default. Now, on the flip side, they would have defaulted anyway because, again, there's no more money to pay. So, and this ad valorem tax on all of Leone, that's a farce. Thank you.
Anyone else have any questions? Okay. I want the vote on the resolution now, because we need to declare default.
Okay, which resolution?
There's the question. It's really up to the board. There's the Board of Public Works resolution, which says they're in default, and that Leone should prepare for an ad valorem tax to tax all of their Leone Township residents for this bond payment. Or there's the other resolution that I prepare, which says exact same thing, except at the very bottom, I took off the part that says Leone has to prepare for an ad valorem tax. Yes, sir.
Mike, even if you go from your resolution, the last paragraph of your resolution has things in it that just lead to more questions. You have in there conversation about looking at the books from the other townships, which I don't think they're necessarily opposed to, but who pays for that, number one, and number two, what do we hope to find? I mean, for me, what I would support voting on is just a clean resolution that says they're in default. This says a little bit more than that, and I may be more supportive of the one recommended by BPW, to be honest with you.
If you do, you're basically saying that Leone should tax their residents for the SRI.
I disagree with that. That's
that's
what
what
I'd be
it
saying,
says.
because the fact, well, that's true. That is what it says in that last paragraph. But the fact is that, again, to reiterate what you've said, Leone has been paying this bond since 2004 to the tune of $2.4 million. I don't think you can argue anything, but they've been paying it from user fees. And they have $3.5 million in unrestricted fund balance that they could very well pay this from, and then let them argue the point. But if they paid it for 11 years out of the user fees, it makes sense to me that that's still where it should come from. But again, for me, a resolution I would support would be just a clean one that says you're in default, you need to pay.
Well, this default resolution here that I propose is the same default resolution prepared by legal counsel last year on 14, and save for one sentence, which has to do with the audit part under Plant Moran audited disclosure. And the last section here that you're referring to does not require us to do that. It says we may. It reserves our right to do that. Again, this was the same resolution that we voted for and approved last year, and leaves open how we're going to resolve this. And while we may not want to be judge, if you will, in all this, the contract that we, the county, signed 10 years ago, or more, a little more than 10 years ago, put us in that position, whether we realized it or not. It did. And the reason the judge, as some have alluded to, didn't go further was because the county wasn't party to that lawsuit initially. And he looked at it and said, wait a minute, the contract says that the county commissioners are the ones who will get to decide this, but they're not party to this lawsuit. So I think that's why he held back. But at this time, it definitely rests on the county commissioners. So what I would propose, again, is that you approve the resolution declaring Leone in default, much like we did last June of 14. And then in 2 weeks, we will have another discussion as to what the outcome will be. Appropriate for a motion regardless which one you motion for. I mean, unless there's more discussion.
I make a motion that we file the county administrator's thorough study of this and his recommendation.
Support.
Any further discussion? You want to read this, Carl? My voice is getting tired.
Yes. Yes, I'm going to. Did you give me the right one? Doesn't.
Carl, I think they meant read it aloud.
Yes, I know this. I'm trying to simplify this. You want, okay, Mr. Chairman, you want the whole thing read from the beginning to end? Okay. Well, then forgive me, I was trying to break this down and simplify it, but if everybody wants to hear it, here we go. Okay. Jackson County Board of Commissioners, Resolution Number 06-15.17 to issue notice of township default under the Jackson County Wastewater Disposal Facility Southern Regional Interceptor Section Bond Contract and Act 185 of the Public Acts of Michigan of 1957 as amended. Whereas on December 1st, 2004, Jackson County, acting by and through its Board of Public Works, entered into the Jackson County Wastewater Disposal Facility Southern Regional Interceptor Section Bond Contract, hereafter the contract, pursuant to Act 185 of the Public Acts of Michigan of 1957 as amended, hereafter the Act, with the Township of Leone, Township of Hanover, the Township of Liberty, and the Township of Columbia. And whereas the contract contains the obligations of the parties related to the construction, operation, and finance of the Jackson County Wastewater Disposal District, Southern Regional Interceptor Section, and whereas pursuant to the contract, Jackson County issued bonds secured primarily by the contractual obligations of Leone Township to pay the installment due plus interest, and whereas the contract states that Leone Township pledges its full faith and credit for the prompt and timely payment of its obligations pledged for note and bond payments as provided by the contract. Pursuant to such pledge, Leone Township is required to pay such amounts from any of its general funds as first budget obligations, and whereas Leone Township is bound by the contract to remit to Jackson County not less than 30 days prior to the due date of any principal of or interest on such bond sufficient funds to pay the principal and interest and any bond service charges then due. And if Leone Township fails to do so, the contract provides that the bond is to immediately give a notice of default with the amount of the default, and whereas Plant Moran audit disclosed Leone Township has sufficient funds in its sewer account to make the January 1st, 2015 payment, and whereas the bond principal of $225,000 and the interest of $77,662.50, and at the agent's fees of $150, totaling $327,812.50 is due January 1st, 2015. June 1st, 2015, and whereas Leone Township failed to remit the bond payment to the county by June 1st, 2015, and therefore is now in default, and the amount of $327,812.50 is now subject to a penalty in addition to the interest of 1% thereof for each month or fraction thereof, that the same remains unpaid after the due date, and whereas in addition to this penalty, Leone Township is required to reimburse the county for all costs, expenses, including without limitation, the fees and expenses of attorneys engaged by the county, actually incurred by the county as a result of the failure of Leone Township to pay amounts when due to the county, including without limitation, the remedies for default set forth in the contract to the extent such actual cost and expenses exceed the funds generated by the 1% penalty, and whereas the contract provides that the county shall have the right to examine the books and records of Leone Townships and the townships. Therefore, be it resolved that Leone Township Treasurer, the County Treasurer, and the Treasurer of the State of Michigan, and such other official charged with the disbursement to Leone Township of unrestricted state funds returnable by the State of Michigan under the Act is hereby provided notice of default pursuant to the contract and the Act for failure to remit payment in the amount of $327,812.50 to the county by June 1st, 2015, and be it further resolved that a copy of this resolution and notice of default shall also be provided to the supervisors of the Township of Leone, Township of Hanover, Township of Liberty, and Township of Columbia. And be it further resolved that Jackson County may exercise any and all rights and remedies provided by the contract and the Act, including but not limited to those rights set forth in MCL 123.747 to effectuate the repayment of funds advanced by the county for the bond payment, plus penalties, fees, administrative expenses, and to examine the books and records of the Township of Leone, the Township of Hanover, the Township of Liberty, and the Township of Columbia relating to the Jackson County wastewater disposal facility and the contract.
We have a resolution that has been moved by Commissioner Rice. Who has supported it? Leitner or Palachuk, which one? Thank you. We have a motion and support. Commissioner Elwell.
Thank you, Mr. Chairman. I think the board should have the opportunity to at least review the recommendation of the BPW and decide on that. So I'm going to offer an amendment to Commissioner Rice's motion, which would include the last paragraph of the second resolution that was offered, and that would allow us to simply discuss that, vote on that. If there's not support for it, then Carl's original would go through. I can read the language if we need to, but it's, Mr. Overton's nodding his head yes. So my requested amendment would be to include a last, be it further resolved that Leone Township is directed to levy and collect an ad valorem tax in the amount owed, including interest and penalty, less the amount received from the state pursuant to MCL 123.747, and to make such payment to the County of Jackson.
We have a motion and an amendment. Is there support for the amendment? We have support. Any discussion to the amendment? Commissioner Rice?
We as county commissioners, as well as our administrator, and I really believe all the townships involved here are talking about fair, equitable. We're talking about the cost to Hanover Horton, the cost to Liberty, the cost to Columbia. We're talking about the fact that whether or not it's right or not right. Even Commissioner Elwell has stated he doesn't believe it's right to have people who aren't even using the system to have to pay on this, and yet we're going to make an amendment that's an ad valorem tax, which would be every person in Leone Township. I cannot, from my perspective, I will not support that kind of amendment. Just, that's my take.
Commissioner Elwell?
I probably won't support it either, Carl, but I believe we should at least discuss it. It did come from a board that we have members on that made a recommendation to us, so.
Mr. Chairman,
Yes, sir.
the amendment only. Okay.
Mr. Chairman, can I ask one final question of Administrator Overton? Mike, you had done the math on it, and I tried to write everything down. I think you said there's 573 users or REUs that come through the Southern Interceptor, and you did the math as $707 per REU or per user. That is per year, correct?
That's annualized, correct.
Right.
And my intent is the next meeting in 2 weeks where we'll discuss this, we'll have on board docs, literally all the math, everything for everyone to see, who would pay what, depending on whatever decision the board ultimately chooses. We'll give all the variations that we can come up with, and if we need to, we'll calculate on the fly some additional ones the board comes up with.
So there could be other options for us to cajole Leone into paying, is that what you're saying, or not?
Frankly, what I've said more than once is it is in the best interest of these 4 townships to work out a deal in the next 2 weeks, because ultimately this county commission will have to make a choice, if not in 2 weeks, at some point in the near future, because we will make the bond payment July 1st, and the county is not in a position to pay an additional $400,000 a year on behalf of these 4 townships. Yeah, I would like to call for a 10-minute break, please. Anybody object? 1 minute. Was there a question prior to? Okay, maybe 5-minute break, please. I was going to say, this is, I don't know if I'd call this lighter or not. We have significant budget challenges before us that we have to address. Not necessarily today, but it's all about the process of working through the budget dilemma. I'll have Adam kick us off from where he left off at the last meeting, and then ultimately I'll move into this other document here.
We talked last time about revenue and expenditure forecast, and I told you that having to cancel our revenue committee team meeting, I'd gone ahead of myself and projected a 1.5%, but that I wanted the feedback of the full revenue committee before we kind of committed to that. So the revenue committee met last week, and we went over all the data together, and we had a lot of discussion, and they affirmed that 1.5% projection for 2016. So I took that number, we extrapolated it, looked at the number that Jim put in for the 2016 budget, adjusted it based on the 1.6% taxable value increase in 2015, which was a change from 1.25%, so I think that was $75,000 or something. And then Jim had plugged in a number for 2016. It wasn't exactly on that 1.5%, so we adjusted that out. Anyway, to make a long story short, we're really not far off from where we thought we were going to be. We're looking at a $1.7 million gap over the next 2 years. We have approximately $1.5 million in fund balance that's above our 24% recommended balance cap, and we're looking to go for $700,000 this year. That projection does include a 1.5% also for 2017, which would mean about another $300,000. That is offset by our contracts, which are set for a 2% across-the-board increase in 2017. As you remember, the contracts were 1%, 1%, 2%. So our actual tax revenue from property is about the same size as our payroll tax. So if we have a 1.5% increase in that, and it's offset by 2%, we're a little deeper in the red, so about $100,000 under. So that's we are where we basically thought we were going to be, and we've put together that program summary that's attached in board docs. That is all feedback that's directly written by the department heads in as brief and concise method as they could. If you want more detailed information, there's lots more detail in the budget document. You should be able to trace every one of those programs back to the budget document where there's performance data, there's 5 or 6 year expenditure history, there's FTE numbers, a lot more data. But we tried to put something together that's very concise. And in the last chart that's in that attachment, let's see, we broke that down into mandated services. Mandated, non-mandated, and internal services. So that's how we've had it broken down. And that $700,000 has to come out of one of those things. One of the things Mike asked me to add to that chart, which I think is very helpful and insightful, is what is the total budget of that program? So in the chart you will see, or in the table you'll see the total budget of that, and then the net cost to the general fund. So for instance, the total cost of the health department is in the $4 million range, but the net cost to the general fund is very little. It's a couple $100,000. So I think that really helps put it in perspective about what type of money the general fund may leverage in those programs. So I can put that chart on the screen for, yep.
Thanks, Adam. Yes, sir. What I hope to do today is work through this net general fund impact by program. I literally want to look at each one of those, entertain some questions, dialogue on it. Not a whole lot of time, but I do think each warrants some individual attention, although be it brief. And we can always schedule another meeting to, spend a lot more time on this, because this is obviously a very significant issue. And I know there are questions that necessarily can't be answered today, although I would like to try to generate some of those questions, as they occur to you. And a lot of times, if you're like me, you'll be, driving along and the question pops up. Just feel free to send it to us, email it to us, so we can work on answering that question, because be assured, if you've had the question, someone else has probably had the question as well, and then perhaps can't bring it forward today. Adam, do you want to discuss what you put up there just briefly, because I know this is a new graphic for them?
Yes, this is the chart of all those programs that are listed in the table, and we've color-coded it there. The first ones on the top are the non-mandated services, and then we have the internal services. Those are the services that support all of those that we're mandated and or non-mandated to provide. And then the last on the bottom are the mandated, and of course this is much easier to see on your own personal devices and than blown up on here. But if you'd like, Mike, I can stay up here and go through the table, scroll through the table as we talk about them and make notes.
Adam, if there's a parentheses around.
Yes, that's the Register of Deeds one. That's because they, those are general fund monies. They bring in more than the actual cost of the program. The cost of the program. It does, and we had a lot of discussion about that. But the challenge there is that they are just the end of many programs that are involved in taking that money. For instance, the person on the front end would be the sheriff's deputy that's on the road who writes the ticket or citation. And then there's the prosecutor who's involved in prosecuting the case, and the clerk who helps with the court in adjudicating it. And then the district court is really just the end of the line in terms of a lot of programs that net result. So that's why we didn't show it that way. It's because it's not simple like that. Good question, though, and I'm glad you asked.
Couple comments I would make that just versus mandated, non-mandated, that sort of thing. Just because a service is mandated does not mean it cannot be reduced. It just means that we cannot drop it below what the Michigan Supreme Court has deemed service or minimal service levels, which is very low, which is, frankly, they don't really define. It's one of those, you need to be able to provide the service as mandated by the state. But, so whatever that minimum is, it probably I'm sure it varies by program or department, if you will. Generally speaking, the last, 5-6 years for sure, the county has whittled away at all programs. We've said, hey, let's see if we can get 2% from everybody, that kind of thing. But we're frankly down to the point where some programs, departments, they don't really have any more whittle room. You're down to more or less the bone, really close. And it's when you're talking, if we just had a little bit of money, we could probably maybe tweak out a little teeny bit of money. But frankly, when you're talking ultimately $1.5 million, that's pretty significant. Something needs to change ultimately to get us where we need to be.
Mike, I can give an example of that. The first year I got here, I believe it was in the 2008 budget, for those of you who were here will remember, Mr. Treacher asked that all the departments cut 25% out of their non-personnel related items. Well, that's contracts, pencils, and supplies. And then beyond that, the next year was, I believe, over the 2 years, was a 32.5 FTE reduction. So some of you were on the board at that time and will remember those cuts, but that's an example of whittling.
Yeah, many of the departments, facilities is the perfect example. They're basically half of what they used to be. While at the same time, we've actually added structures for them to clean, square footage, if you will. So everyone is doing more with less, there's no doubt about that. And go ahead, Carl.
Adam?
Yes, sir.
You and Mike might have an answer to this, but if not, and look, as I've looked over this budget, and I know all of us commissioners have sent in comments and questions and so on and so forth, which is great. But if you look at, and like Mike said, even the mandated items, or the mandated amount of money that we're talking about, potentially that could even be reduced. Obviously, there's a benchmark that we can only go so far if we needed to. But my question is this: since we have talked about the sheriff department having the biggest budget and so on and so forth, first of all, we have, if you break it down, if you look at this chart here, just approximation here, you got about $4 million that's part of the jail, which is mandated. Then you have $4 million, which is part of the road patrol, give or take, and that's not mandated. The sheriff and his salary and the undersheriff and his salary are mandated. So I think we need to take those two salaries into consideration. We also have to take in consideration the mandated county jail. And I also think we need to take in consideration how much of that money is contracted and paid for by townships, such as Summit Township, which contracts, for instance, with the Sheriff Department. I think we need to take all of that, and then at the end of the day, take a look at and see actually what the Sheriff Department is actually paying, that we are paying for the Sheriff Department. Because I think we could go from that $8 million and dwindle that down quite a bit in terms of actual money that's not mandated, if that makes any sense.
It does, and we've tried to make it as brief as possible, but the sheriff helped us break that part down in that description section. You'll see the computer froze up here, but there's a number of deputies that shows their contract, and then shows that are above and beyond those contracts that are not part of the administration, because it's also not just the sheriff and undersheriff, but they would expect to have some administrative help too.
So Adam, when we're looking on page 3 here where it says non-mandated road patrol, that $3.9 million there, does that exclude that's just general fund, that excludes the contract monies we've taken in? Or no?
Right, that excludes, the net impact excludes all those.
So my point is that the numbers in front of you here, where it says total net cost, that's the general fund. So we've already taken out the things you described, these contracts. And now where it says mandated in county jail and those things, I mean, that's obviously the sheriff and so forth in there. But the non-mandated, we do spend, $3.9 million plus for road patrol.
Okay, and that clarifies, and I appreciate that. Thank you.
Yeah.
Yes, sir.
You were pointing at me, I didn't know if it was to be quiet or what. Or not you again. Oh. Well, we're going to go, item, but I just want quick clarification on one other one, which is on page 4, and it's the truancy grant, and I had sent Adam a question on that I think made the list. But Adam, if we were to split those, not that it's confusing this way, but you really have two things in there. You have the truancy grant, which is it really a grant? It's more of liaison officer, is it not?
Yeah, it's school liaison officer, but some of it's grant funded.
Grant funds through the county or through the schools?
Through the schools.
So in other words,
It's a grant, it's a contract, really. Yeah, that's probably more.
Right, so they're getting a grant, and then they're in turn paying us.
Right.
Is it fair to say that on I'll call them liaison, because that's what I'm familiar with, those positions are not fully funded by the schools for the time that they're there?
Yes, but I would also caution, we haven't, between that and the Marine Patrol, we've got to get a better separation of the cost, because
That's what I'm getting at.
yeah,
Right.
and those I haven't fixed yet, so I'm glad you pointed it out. Those are the only ones we can get to this week and fix those.
But the Marine Patrol is not grant funded or contract funded, that's strictly general fund.
That's right, yeah.
And it's also relevant, I think, that the sheriff, I think within the last year or two, switched from using part-time people to staff the Marine Patrol to using deputies
Right.
at a higher wage for that. So I guess I'd be curious if there's been any thought given to going back to using part-time, appropriately trained staff for that would save those dollars and yet still retain the program.
The idea was in the summer, those school resource officers went on road patrol. And at the time that we switched over to the Marine Patrol, that was the sheriff's way of reducing, because that was already built into the road patrol budget and the school resource officer budget. So eliminating the casual or part-time Marine Patrol positions, he took those two positions off the road for the summer and put them into the Marine Patrol. So it was a savings, and it still is a savings, because those, but it was a reduction on summer patrols in the throughout the county of 2 officers.
Thank you.
Yep.
Adam, has any attention been given to the Marine Patrol to operate it in such a way as the Mounted Patrol to volunteer?
That's a question we can ask the sheriff.
I mean, we supply the equipment, and you can have a good citizen volunteer go out and do the actual patrols.
Yeah, it's certainly a question we can ask.
Thank you.
Yeah. I know typically search and rescue divers are a lot of communities use those as volunteers. A good friend of mine is one of those, but I'll put down that question to ask the sheriff.
Questions other about specific items on the net general fund impact? Yes, sir.
Well, just another clarification on the animal shelter. I'm curious, it's got a total budget of $297 and it's only a net cost of $94. Where are we getting $203,000 from? I mean, is that from donations, or where does that come from?
Yeah, that comes from adoptions primarily, and donations. So we get a lot of donations there, but many of those are probably not even monetized in the budget, because a lot of our companies here and businesses here in Jackson actually will drop off food on a regular basis to the shelter donating. But the actual dollars there is from adoption of cats and dogs. And you remember probably 4 to 5 years ago when we started the spay-neuter program, we had that spay-neuter fund, and so we subsidized the cost for as over a period of 4 years, and each year the adoption cost went up, and we should be at the max of where that forecast was of for adoption rates. And there's still actually some of that fund left.
This is one of the reasons we put the budget on there, was because we wanted to make sure the board fully appreciated the magnitude of the impact on making a change to a program. While the animal shelter costs the county general fund approximately $95,000, it really has a, if you were to say, well, we're going to save that 95 and close the animal shelter, it's really a $300,000 impact to the community, so that's why we've asked for that there. Other questions about particular programs or departments on here? Now's
Mike,
the time. Yes, sir.
Let me just comment
ahead.
something about going back to that Marine Patrol. Certainly, we can ask the sheriff that. The question is where do those school resource officer positions go in the summer? And do they become casual and they become, or part-time? So that's something we can ask them too, but I just wanted to clarify those are actual full FTEs that are, well, they're not maybe necessarily the same people. They are shifted from this school year to the summer. I'm pretty sure they have a casual budget, and we can get that number to you, how much it is.
Yeah, there will be union contract issues at some point there too, where if we displace full-time with, casual, I can't quote chapter and verse of the union contract, but I'm pretty confident that's probably in there somewhere. It generally is. Not Marine Patrol, no.
Yeah.
But if we were to displace Road Patrol. Yes, John?
Thank you, Mike. Do we know how many sheriff deputies may be retiring over the next year?
Well, we certainly have the drop list and the retirement list, so we probably have a pretty good idea over the next year. I don't have the number in front of me, but could certainly get that to you. There's enough turnover in attrition in the sheriff's department with that size of the department. It's our largest department, so that any type of reduction of force could be likely done through attrition. But not only have you retiring, but it's a challenge to find qualified deputies. The HR goes through the testing, helps them with the testing, and it's difficult to get solid candidates.
Adam, if I could ask another question. Nope, yeah. Are we confident that all of our contracts, we've got a number now, but do all of our contracts for deputies fully pay for the service? And I guess finance would know that, or Mike or Adam, I guess, would. Are we confident that that does happen? We're fully made whole for the cost of the contract, actually?
I can give that with pretty high assurance. But
Yeah, the whole point of it, and our conversation with the sheriff, and he very much agrees that they need to pay for that service. So while there is potential, I suppose, for an error, but by and large, that is the intent, that the township's contracting with the sheriff's office would pay the freight for that officer and equipment and vehicle and so forth.
Mike, Mr. Tallis just handed me a note as a good reminder that some of the townships, Hanover Township being one, pays for extra marine patrol on the lakes and weekends. So, I mean, it's possible to go completely to a pay-to-play scenario on marine patrol.
Sarah, then Phil?
On some of the mandated things you mentioned earlier, there's a service level that we have, and I'm just looking at the prosecutor's office, and there's no comments or anything like that. Where are we at as far as the mandated service level for them? Because they have almost a $2 million impact on our budget as well.
I can tell you that we have not spent a lot of time looking at the mandated services because of the cuts we've had in the past. We believe the mandated there's not a whole lot there. If we start making cuts there, we believe we really need to look at not being all things to all people, because we cannot successfully do it with the budget that we have available. Truth be told, I would rather do less and do it well than do more and do it mediocre at best.
I can add something to that too. The prosecutor has come forward with a few programs that would not only generate some revenue, but more importantly, probably help local businesses, such as a return check investigation or bad check writing. It's not going to solve our budget problem, but he has tried to. He's actually had quite a few conversations of different areas where they could get into an investigation and to help out the county. But we don't. The minimal service level, you really don't know until it's tested and gone to court.
I'd like to talk about something that seems probably on everybody's mind, but hasn't been said yet, and that's road patrol. I'd ask Mike and Adam to get me some information, and they did provide this. 80% of the residents in Jackson County either live in an area that have their own police patrol and police department, or they are contracting for the services, such as Leone contracts through some, or Blackman, or Norval contracts through the sheriff department. That leaves only 20% of the people without a road patrol. I don't think we can, let me preface this with saying, I don't want to get in hot water, but public safety is my #1 priority, even though we had moved it to second place, I think it was last year, and put economic development at the top. I think that public safety, if you don't have that, you're not going to have economic development. And I also really hate to do any cuts in the in the road patrols, because it's such a drug problem that we have. And that just, I think, really accentuates the number of arrests we have through the road patrols because of the drugs. So it seems like the wrong place to focus on a cut, but listening to the conversation going around the room, we're just taking little bites around the edges here. We got $1 million or $700,000 to find this year, and I don't see any place we can find it other than road patrol. And that's the last place I want to cut. But through attrition, maybe we could get there. I don't know. I don't want to cost anybody their job. But there isn't much other place to cut to get to where we need to be.
Yeah, I think that number was 82% of the population of the county was covered by contract or their own police department or the city.
How much
police department
should they want, excuse me, 1 second, I'll let you have. Should they want road patrol in the areas that don't have their own police department or their own contract with the sheriff? What would it cost to, any idea what it would cost to kick into the budget so they can have road patrol also with the sheriff's department?
Yeah, they have an annual number per FTE, and it's based on the hours of coverage that the municipality wants, so that the sheriff has developed those and is consistently.
I mean, they would still get police services. There'd be a 911 call responded to, just wouldn't be the road patrols, I guess. Watching for speeders or just driving through the neighborhood, keeping everybody honest, I guess. But I don't see another place we can go. Thank you.
As a follow-up to Commissioner Duckham's comment, 82% of our population currently has their own road patrols, was your statement. Of that 82%, where are we looking at? What's the data in regard to 24 hours a day road patrol versus a part-time road patrol?
That's certainly a fair question, because not all of those 82% have 24-hour coverage. Some of them are just 8 hours a day or 10 hours a day. So I don't have the answer to that, but it's certainly a fair question and a good point.
Thank you.
Just a question of clarification. When you say 82%, leaving 18%, is that just by raw population number, or is it by municipality, the percentage you're talking about?
It's by population number, not municipality.
So you could have technically a number of municipalities without coverage then?
I mean, if I had to guess just from looking at that map, I mean, it's probably, it's probably 20 to 30% of the land area of the county that's not covered. But,
And also, not to overstate it, but just to state it, that we do have state police covering also.
Adam, I believe that was 6 townships, if I remember right.
Okay.
There are about 6 townships and all pretty much rural townships, but
Right.
that was the area.
Yeah.
Other questions, concerns? Well, let me just say that you know, we're looking at a 2-year budget, and we're looking at, obviously, we want to adopt our budget August, September, prior to the state beginning of their year for some of our other departments. That's for 16. Well, at the same time, we want to have 17 pretty much in the can too, or at least the plan for 17, with the same expectation that come August, September of 16, we would adopt 17 and have 18. That's kind of our cycle. We do feel that for 16, it really is about making cuts to programs, or reducing or eliminating, or it's really about cutting. And 17, we believe there is opportunity for revenue. And I'll raise it now. The 911 fee that everyone pays on their phone bill is 44 cents, I believe, per phone. The average in the state of Michigan is $1.05. We're way below the average. Currently, we subsidize, that's not the right word, we provide roughly $700,000 to 911 from the general fund. If we were to increase the 911 fee that we all pay on our phone bills, we could take the $700,000, basically supplant that, leave it in general fund, and cover the year 17 budget shortfall. And that would be a permanent fix to that. That does require a vote of the people. And frankly, without a special election, in my mind, the real first opportunity would be August of 16 to put that question on the ballot. So I'm not asking for a decision, but I'm asking for, be thinking about that, because we put ourselves in a difficult situation by having a fee that's more than half or whatever, or less than half, if I'm saying that correctly, than everyone else's. The average in the state is $1.05. We're at 44 cents. Again, takes a vote of the people. But yeah, that would free up that general fund monies that we give 911 now to use to offset our budget shortfall for 17. That doesn't help us in 16. We still have some tough decisions to make here in the next few months. But, yes, sir.
Mike, right now, we're contributing, I think, $663,224 from general fund to operate 911, correct? And the rest of the $1.6 million comes from surcharge money, correct? Of that 44 cents, but there's also another fee also, and that goes into a separate fund that's used for what?
Yeah, there's another fee that goes into directly to the utility companies. A third party that's monitored by the state does the cost estimation of what they need to keep up the infrastructure, and then the work is done and they're paid. The utility companies are paid. Mostly, I believe that's Verizon and AT&T.
And that fund is how much per year to the county? in,
I have that number, I don't have it in front of me, though.
not 663, anywhere near that, or is it? And is it restricted in any way for how we spend it?
Yeah, are you? It would be restricted. Yes.
Well, but to 911, correct?
I was going to say, it'd be restricted to 911. Remember the Bolt decision, taxation without representation, that sort of thing. We can't use enterprise dollars or special revenues for general expenditures, if you will. What we can, though, is take, like I say, is basically supplant the money that we give from general fund, which would solve our 17 problem. So from that perspective, that's true. That's a go-forward solution. It's not a one-time fix, which would be very helpful. At any rate, yes, Adam, go ahead.
And Commissioner Elwell and I attended a presentation by the Sheriff's Department on the state of the 911 county radio system, and they've put together some numbers that for their infrastructure needs, because not only are we subsidizing or we're paying for that program out of the general fund, but we also have unmet capital needs on that. So there's an opportunity to fix two things. One is to fully fund the operational side of 911, but then also to meet the radio needs that are evolving and changing and perhaps could change in the future with additional narrowbanding.
Yeah, and as I had expressed then, I'm hopeful that as we, as commissioners, get to participate in that we take a long, hard look at how we study that, and that we look at potentially bringing in an outside entity to help us sort through what's in the best interest of our county infrastructure needs for the radio system, instead of using currently an internal service provider to us to make recommendations. And I had mentioned to both Adam and Mike that Lenawee County is currently looking at their radio needs. They've hired an outside consultant that doesn't do any other business with them to help them make recommendations. They're looking at some of the same issues we are, and I think all of you here know that I've been using the system here, radio system, since 1980, so I have a little bit of knowledge about it, and I'm hopeful that we can make decisions that spend the money wisely.
We know obviously the operational gap, and I think we have a better idea now of what the capital needs are, but there's also a lot of wisdom in getting a third party to look at it and tell us based on other information they know.
Adam, do you have an idea of what a special election would cost the county to conduct?
I think the clerk does, yeah.
Anyone else have questions in particular to any particular item that we have, program or budget or otherwise? In all honesty, my intent was to go through these kind of line by line, but for the sake of time, and I thought, well, we won't get away without revisiting this, I'm sure, but I did want to try to get through questions, at least more immediate. Did anyone else have anything? Yes, sir, John.
Yeah, Mike, I think one of the things that I would like, and I guess he's gone, is when was the last time we had any increases in the fees or leases at the airport?
It's scheduled for review every year and done every year. Yeah. Some of it, though, is tie-barred to federal rules. So we stay where the best we can within the law. Yep.
That is something, though, that I would like to have the board every year look at that. It's one of those practices where you literally have a fee schedule. It's multiple pages. You don't change every fee every year, but it comes before the board for renewal every year. and therefore it gets a look, and some fees may have to go down, some may have to go up, because a fee is just that. It's supposed to pay for the service. If it's more than the service requires, it becomes a tax, is what the law has said, unless, if the board chooses to subsidize some particular fee for the purpose of some stated purpose, like economic developments. For instance, you wanted to subsidize building inspection because you want to encourage building. But at least you do so knowingly, and you're evaluating that every year. So just, look for that as something that, to look forward to. Well, maybe not look forward to, but something that will come forward. Yeah, there's a question down here? Phil?
If we chose to move forward with a 911 surcharge referendum, it would need to be a special election, I believe, because we need to know for 17, don't we?
No, 16.
Okay.
This is 15. So next year is 16, and then it would go in and come on in 17, which is our budget year.
Thank you.
Other questions? Adam, you have anything additional you want to add? Well, again, I would encourage you to send us questions, thoughts on where we might look, and we'll be, and stay tuned, you'll be hearing from us soon in regard to budget as we move forward on this question.
We're at other items. Any commissioner want to bring forward any other items? Go ahead, Sarah.
Yesterday, the Michigan Department of Ag came out with a ruling that there will be no poultry or waterfowl exhibits, shows, fairs, any of that in the state of Michigan due to the avian flu. MSU Extension actually has a poultry show fact sheet on their website, and I printed a copy as well. Has multiple questions because obviously we have kids with fair projects that aren't going to be able to be at the fair. They're exploring other options to be able to still sell their animals. I know one of the things right now is they'd still conduct an auction, but it would be via picture. I don't know what our fair is going to choose to do at this point, since this is relatively new. We just got the press release yesterday. But anyway, so there's going to be no poultry or waterfowl at the fairs in Michigan this year.
Any other commissioners? I have one for the administration. I realize that you're very, very busy, but my Commissioner Rice and I have had the opportunity to speak at length about this, and we hope that the other Board of Commissioners feel it prudent and important to talk about. There is an opportunity for the Board of Commissioners to find revenue to fix our roads. Well, although it needs to be voted on annually by the Board of Commissioners, I think all the commissioners need to understand what is entailed in this, and I would like to ask the administration for the August study session to review what the resolution is that we have to pass and what the monies can be spent on, what the monies can't be spent on, and a better understanding of how that 1 mil, if it is 1 mil, can be levied. I know that Commissioner Rice has reviewed quite a bit of it. I began reviewing it. I'm sure Christopher would love to explain it to us. I do realize that something was defeated here, but this money would only be used for roads, and it would be, from my understanding, would be voted on annually by the Board of Commissioners. So it's something we would do in January with the explanation and everything ready to go. I have a couple of township supervisors who appreciate us at least looking at it and studying it and coming up with a conclusion. Yes, it would be raised in the city, so that would mean we probably would want to talk to the city about them getting their share back. So we'd want to make sure no one is being gypped, if you would, or taken advantage of. So that's what we need to understand, Michael, and it would be appreciative if you would return us in August study session with an answer on all that. Thank you. Any other commissioner comments? Commissioner Duckham.
Question, Mr. Chair. That money you're talking about as far as the mill for road repair, that would be used as match money?
Phil, let's learn what we can do with it. I have no idea. That's why I posed the question to our administration. We return to public comment. Oh, go ahead.
Just wanted to say thank you to Mike and Adam, for answering all the questions that we have about the budget.
Yeah, I believe that is very appreciative of commissioners, and when we're dealing with a tight budget like this, there's not a bad question. Don't think that. Ask the question, and let them get us all the answers, so it's shared with all the commissioners, similar to the factoid Adam has put out. That's been very helpful to us all. Again, public comment for the second time. If you'd like to address the board, you have 3 minutes.
Good morning again. Again, my name is Tom Daniels, the attorney for Leone Township. I stayed because I wanted to make one comment in response to a portion of the board's discussion about the SRI bond contract, and that is the idea that Columbia Township didn't gain anything from the SRI bond contract. As we've pointed out in previous communication to the county administrator, and we'll send it back again regarding not only REU counts, but this particular point, there's a wastewater services agreement, which was the sister agreement to the SRI bond contract, and if you review that agreement, you learn that Columbia Township got money to expand its equalization basin. It was $477,000. It came from the Round Farwell Lake bond funds. They also got an enhancement to the Clark Lake Interceptor. The cost was $300,000. That was also paid for by the Round Farwell Lakes bond funds and SRI bond funds. And you've heard a lot of talk about the connection fees that were anticipated to pay debt service. Included in the connection fees that were anticipated was a $314 connection fee that was to be paid to Columbia Township. And with the connection fees that were projected at that point in time, the growth that Mike has talked about here today and other people have talked about here today, from 2008 to 2028, those growth projection fees would have paid to Columbia Township $3.3 million. So there was quite a lot of incentive on Columbia's Township's part to participate in this, and there are other matters that were very much to Columbia Township's advantage back in 2004 when they signed this contract. And I also have some additional information for you on REU numbers. Some of the numbers that were provided today are inaccurate, and I'll provide those to the county administrator. And the detail on the advantage to Columbia Township under the SRI bond contract and the wastewater services contract, I'll also get that to Mr. Overton.
Any other public comment?
Peter Bournemouth. I wanted to echo Commissioner Duckham's comments on the fact that the road patrol is a potential place for budget cuts. Obviously, 911 is an essential citizen service. I agree with Mr. Overton. I hope that you will ultimately place that on the ballot. I think the people would support that increase. But I wanted to disagree with one thing Commissioner Duckham said, saying that, you know, we do have a drug problem in this community, but I don't believe that road patrol really does that much to solve that problem. It's not a problem that exists on the roads as much as it is a problem that exists in residences or in other places where they might be manufacturing drugs. So I didn't feel like that was, you know, exactly tied in to the issue that you raised. Thank you.
Just a couple of thoughts, again, Wyvern, Napoleon Township, in response to some of your budget discussions. The $75,000 cost for a special election, if you were going to think about having one, you might also consider whether there are other issues that you might want to put on that ballot that in combination with the one that you're talking about might justify it. Also, if other municipalities, townships were aware that there might be an opportunity to participate in a special election, they might have issues they otherwise would not bring to election, but might in conjunction with you if it could save them some money. So just some thoughts to consider on that. Also, with regard to sheriff road patrols, Napoleon Township has its own police department, but I've always viewed that as in addition to sheriff's service, not instead of, since our residents pay the same taxes into coverage of the sheriff's department as anybody who doesn't have their own local police department. So I'd suggest you be careful about thinking that the sheriff's department would only patrol those areas that don't have their own police department.
John Tallis, Hanover Township Supervisor. I've instructed Kevin Thompson to get in touch with Mr. Daniels. That's going to happen this afternoon. We want to meet with the 4 townships and talk about the resolution of how this is to be handled and the most equitable way to do it. And we hope to be able to send you a written fact sheet on that. On radios, Sheriff Rand, we're going to turn in today, Sheriff Rand is coming to Hanover Township either the 21st or 22nd of this month. All commissioners will be invited, all supervisors, fire and police personnel, and he said it's a program that no one has seen, and he wants to talk about radio issues to us. So if I told him I would open up Hanover Township, we've got plenty of room, and so that's to be set up today. So thank you very much.
Todd Britton, Leone Township. I want to thank everyone for the votes that you did today in support. I did want to just point out a couple of things that I would just want to put to rest a mythical rumor that was mentioned earlier at this meeting about Leone Township using user fees to pay that $2.4 million, because that's not true. That money, Leone Township had its own system before Grass Lake tied in, Napoleon, all these other townships, Columbia. Before they ever tied in, we had our own system, and our residents paid through non-routine and routine maintenance. We were paying $10.25 per month. It was divided up between routine and non-routine maintenance. You multiply that and go back, we had, I think it was close to a little over $3 million, which was supposed to go to replace the lines in Leone Township. In Leone Township, when the lines go bad and there's breaks and this and that. So I just wanted to put to rest that mythical rumor going around that Leone used everybody else's money. Almost 80% of Leone Township's residents are on gravity. Which gravity, there's almost $0 to maintenance on those. We don't have grinder cans, which grinder cans, you're talking, when those go bad, and they can last maybe up to 10 or 20 years. When the grinder cans go bad, that's where these other townships that are on grinders, that's their big maintenance fee. We have almost, vast majority of it is gravity. So there's $0 to maintenance on that. So I wanted to bring that up, and then it was, Mr. Overton brought up about why did Leone Township pay $2.441 million? That, I was elected in 2008, and back then, the predecessor before me, Kip Ballast, he was a supervisor before me, he had said, well, we've tried to get this squared away back in 2008 prior to me coming in, and there was another issue with the drain commissioner where they took money from Round Farwell, well, they took it out of Leone's money and gave it to, it was misappropriated through the Drain Commission office. But if you do the numbers, 2006 it was only $116,000, 2007 was $198,000, and then 2008, you add those together, it was $198, it would be $504,000. Since when we started all this
30 seconds.
Trying to negotiate with the other townships and then going through all this lawsuit, that's where almost $1.8 million has all acquired. I mean, so there was nothing, we had to pay it. We were told if we didn't pay it, our residents were going to have an ad valorem tax, and we had to pay it. So thank you.
Any other public comment? Seeing none, we are adjourned.